Man, this shit finna piss me off.
You are being recorded, so you may want to mute yourself before you get yourself in trouble. Okay, thank you.
Miss Felder, you're gonna need to get out of your bed if you're gonna be on this calendar.
Blunt. Norris. Blunt. Anybody. Somebody. Francois. Anybody reset?
Tucson,
Yes.
position number 8 may be our medical reset because he wasn't interviewed today. The same as yesterday, he will not talk to anyone.
Okay. Thank you.
Who's position A? Is that Holmes?
Yeah.
It is.
I'm waiving his appearance. Mr. Howard has had the opportunity to speak with him.
Oh, okay.
Mute bence. که میگم تو میتونی ببندی نگاه هم بستم.
All right, good afternoon, everyone. Good afternoon, everyone.
Good afternoon.
Good afternoon. We'll get ready to start, ladies and gentlemen. We're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused these cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to address several matters, including bond, a possible arraignment, and a possible plea offer if one has been made by the state at this juncture. I want to begin by reminding everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. What is our, and I guess I should look in, I don't see anything. Our SAP reset date is July 13th. July 13th is the reset date. I also want to remind and advise the defendants on this calendar that you have certain constitutional rights. The first being that you have a right to representation at this juncture in your case, and you should know who your attorney is by now. You also have the constitutional right to remain silent. Remember that anything that you state about the facts, the circumstances, and the occurrences of your case can and will be held against you. So govern yourselves accordingly and listen to your attorney. All right, who do we have first on the calendar?
Your Honor, can we put Ms. Kim, courtroom 3, in the Russian interpreter in the breakout room, please?
That will be good, yes.
Come on, Ms. Phillips. I don't see Ms. McBride. So we have them. I'm Ms. McBride. No. I was talking to Ms. Perez. I don't see.
I am here.
Here it is. Okay, come on, Ms. Perez. Okay, we're gonna also do position number 15, Ms. Perez, and that's Ms. McLeod's case.
Okay. That's the one we're doing first.
Yes, and then, okay, they already went on the breakout. Okay, thank you.
Okay.
So this number 15?
Yeah, position 15, Perez.
All right, this is 23 CR 004064A. Mary Perez, charged with 1 count of simple battery, pretrial.
Second arrest, 2019 DUI, dismissed.
All right, state.
Yes, Your Honor. This incident happened yesterday at 4132 Shireen Way in South Fulton. According to the warrant, the defendant wrapped her arm around the victim, Mr. Aaron Caraway's neck, and choked him. According to the victim, the incident is captured on video and was recorded by his phone. At an appropriate time, we'd like to call for the victim if he is present. Due to the fact that this just happened yesterday and there has not been an adequate amount of cooling off period, the state is recommending $3,500 surety bond, no further contact with the victim, Mr. Aaron Caraway. Stay away from 4132 Shireen Way, South Fulton, no alcohol, drugs, and weapons, and anger awareness.
Good afternoon, Your Honor.
Good afternoon.
My client is 40 years old. She is gainfully employed and she has a bachelor's degree. She is the mother of 3 children, one of whom is only 14 years old and a minor. All 3 of these children are currently living with her in her home, which is the address at which this incident is alleged to have taken place. The victim is her 19-year-old son, the alleged victim, Your Honor. My client tells me that her son was disrespectful to her and that he actually got physical with her. When she remonstrated with him because of what he was doing, she touched him, he took out his phone and started recording. She tells me that her son is upset with her because she has asked him since he's 19 years old and he's employed to vacate her home and go live elsewhere because he really has been giving her a lot of problems following her rules and her regulations. So this is what caused this. In fact, my client was the one who called the police because she wanted some help with her son, and they ended up arresting her. My client tells me that she does love her son, and she would prefer a situation of no further violent contact, although she does want him to leave the home, and she had already given him notice to leave. I believe she said by the end of July. And this is part of why he's upset with her. My client has no criminal history of any kind of violence or anything, Your Honor. She's raised his children. She has a minor one, and her 21-year-old daughter also lives in the household, as does her 14-year-old. So for her not to be able to go back to her own home and to her minor child is going to be a real problem for her, Your Honor. I would ask the court to give my client a signature bond so she can get out of jail and go back home to take care of her minor child. She is not in a position to just give up her home because she does have her child who lives there, and she needs to be at her home, and she doesn't mind no sort of violent contact with the alleged victim. Nothing further, Your Honor.
All right. I don't, normally, I guess with the victims, we're not in the business of putting the victims out of the home and where they live. And I understand that this victim here is 19 years old. Is Mr. Aaron Caraway on the line by chance at all? I don't think he's on the Zoom call. And I understand the situation. It's his mother and son. But there certainly has not been the ample cooling down period. So I do want to make sure that the victim is safe and that there will not hopefully be any more incidents. I'm going to order a $3,500 signature bond. And I'm going to order that signature bond be through the jail. I am going to order no drugs, alcohol, weapons, or guns while on bond. As far as the stay away and the contact, I'm not going to order a stay away, but I'm going to order no further violent contact between the parties, and hopefully they will be able to sort things out and work it out. And I guess that's all I'll order at this time.
Thank you, Your Honor.
All right.
Next, Judge, we can do the private attorney's case. Caleb Lindsay.
Good afternoon, Judge. Attorney Kevin Fisher for Mr. Lindsay.
Good afternoon.
Position 12.
Okay. This is 23 CR 004058J. Caleb Lindsay, charged with 1 count of battery family violence. Pre-trial.
Second arrest. Last was 2020 ag assault weapon, battery, burglary with assault or battery out of Florida. It was non-process.
All right, state.
Yes, Your Honor. This incident happened on June 26, 2023. Officers responded to a domestic dispute call at 370 Peachtree Hills Ave, apartment 12. Upon their arrival, they made contact with the victim, Ms. Jennifer Lee. She informed officers that she and the defendant had got into a verbal argument and went into separate rooms. She stated that the defendant then came into her room intoxicated and began to try to have intercourse with her. When she refused, he became upset, jumped on top of her, covered her mouth with one hand while the other hand was around her neck. She stated that she could not breathe and she bit his hand that was covering her mouth. She then fled the residence in her underclothes. And once she informed the defendant that she was calling the police, he left the residence. Our office was able to get in contact with the victim, and she stated that she would be on Zoom for this hearing. So at an appropriate time, we asked that you sound for her. She informed us that they do not have a violent history, but she does fear the defendant when he's under the influence of alcohol. She states that he's a different person when he drinks, and has a past, and she feels that he needs further help. She did confirm the events in the warrant, and she stated that she would like no further violent contact, and for him to participate in anger awareness and alcohol evaluation. And she would like for him to return to the residence. However, Your Honor, the state feels that this incident just occurred a few days ago. So there has been some cooling off period. However, they still live together. And based off the events of the incident, our office is asking for a $5,000 surety bond, no further contact with the victim, Ms. Jennifer Lewis. Stay away from 370 Peachtree Hills Avenue, apartment 12. No alcohol, drugs, or weapons, ADET, and anger awareness. And we ask that you sound for the victim, Your Honor.
Okay. Is the victim Jennifer Lee on the Zoom call? Jennifer Lee?
Yes, Your Honor, I'm here with Jennifer Lee.
All right. Do you wish to make a statement to the court today, Ms. Lee?
Yes.
All right. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. You can put your hand down. All right. What is your statement?
My only statement is that he's able to get his stuff and just be able to move forward with leaving the residence on a good note.
Okay. Are you in fear of Mr. Caleb?
When he's under the influence, yes, I am.
You are? Okay. And I'm sorry, I think I mispronounced. His last name is Mr. Lindsay. All right. And you don't want to have any contact with him right now?
I don't mind him coming to get his stuff, but I don't feel like a stay away agreement is necessary. But I mean, whatever y'all recommend.
Okay. And I'm assuming that's because he does not reside with you?
He does reside in the apartment that we stay in. We've been in the same apartment for over a year.
Okay. All right. Any cross-examination by the state?
No, Your Honor.
Any cross-examination by you, Mr. Fisher?
No, Judge.
All right. All right. Thank you, Ms. Lee. You can mute yourself. All right, Attorney Fisher.
Hey, Judge, thanks. I'm in the back of a courthouse right now, so there may be some background noise, so I apologize.
Okay.
I heard some of the facts of the case. My understanding is that alcohol or drugs was not involved. There was a misunderstanding that was exaggerated by Ms. Lee, which just turned into something that it shouldn't have turned into. He does reside in the same apartment with her. He is gainfully employed. My client, hang on one second, Judge.
Okay.
Is 30 years old. He's been working at the same place for about 2 years. He has no prior felonies. That you heard from the history that has been dismissed. He poses no threat or danger to anyone or anyone in the community. He's not a flight risk because he's got a job here and he resides here. He's not going to commit any violent felonies pending trial, and he's not going to intimidate any witnesses or obstruct justice. We are asking for a signature bond, Your Honor, lower than $5,000. That would be reasonable. I believe there is some possessions that are in the apartment that he would like to get, obviously being escorted by a marshal. I don't believe that anger management or an alcohol drug evaluation or no alcohol or drugs or not having any weapons is appropriate in this case.
All right. I'm going to order a $5,000 signature bond through the jail. I'm going to order with that $5,000 signature bond through the jail. I'm going to order a one-time law enforcement escort to return to the property to retrieve his personal belongings. I'm going to order no drugs, alcohol, or weapons or guns while on bond. And since he is gainfully employed, I'm going to order him to take a one-day anger awareness course. And I'm going to order him to have no further contact with the victim, Jennifer Lee. And with that no further contact, to stay away from 370 Peachtree Hills Avenue, apartment 12. So he will need to find somewhere else to stay. Other than that, I don't have anything else. Anything else, counsel?
Judge, I think there is a firearm either in her possession that it belongs to my client's father. We would like that returned.
Miss Lee? Are you still there?
Yes, Judge. Yes.
Is there a firearm in your
Yes,
possession?
Judge, it is.
And does that firearm belong to Mr. Lindsay or his dad?
It belongs to his dad.
All right, I would ask that you, Mr. Lindsay cannot be in possession of any firearms. Are you comfortable returning it to his father, or would you like to return it to the sheriff's department?
I would like to return it to the sheriff's office. I don't feel comfortable with his dad. He is yeah, he doesn't deal with certain people.
Okay, so and I don't know if I misstate, is it the sheriff's department or the marshal's department?
Sheriff's office.
Chair.
All right, so you can return that firearm to the sheriff's department within about, I'll give you 72 hours to do that. And then, Mr. Fisher, if you can inform the defendant's father that he can go there and pick it up or inquire.
Yeah,
as to how
my
to
client,
obtain-
my client's parents are on their way here, so if we can maybe pick that up tomorrow, that'd be excellent. Otherwise, they're leaving town this weekend.
Oh, can you return it by tomorrow, Miss Lee? Take it to the sheriff's department by
Return it
tomorrow?
to, yes, I can.
Okay, all right.
And what would be the location for that address, Your Honor?
I don't know. Good question. Mr. Jordan.
Yes, sir.
When they return that firearm to the sheriff's department, is that going to be here at the courthouse or somewhere else? Where is it normally taken? I must say, I'm not going to give out any bad information.
But I'll have to do some research for you because we haven't had anybody have to turn any weapons into the sheriff's office yet.
Right.
You want them to bring it to 185 and then they get arrested trying to come in the door.
Exactly. And that's what
So-
was going through my brain.
I'm gonna have to do some research for you.
Judge, can I make a suggestion?
Yes.
When the marshals escort my client, his parents will probably be helping him. At that point, can the marshals hand the gun over to my client's father?
I wouldn't want to put them in that situation. Normally it's not done that simple either. We'd like the gun to be secured, make sure that it's empty and there are no bullets, and that would need to be done by a law enforcement official. So I'm not happy about that. If anything, it'll stay at the sheriff's department until the parents come back in town to retrieve it. The father, where do they live?
They live in Florida, near Pensacola.
Okay, so they're not terribly far away. So it would be in the property of the sheriff's department until he comes to pick it up. I just don't know if we're going to be able to do all this that fast. And we're also requiring Miss Lee to take it somewhere. We're going to need to let her know where to take it. Victim witness with the state, ASG Stafford. Can we get a message to Miss Lee through you all and letting her know at the end of this calendar or by tomorrow where to take that gun? Or where
Yes,
to
Your
turn it in? Okay.
Yes, Your Honor.
Miss Lee, you've been talking to a victim witness advocate, I assume, from the solicitor's office. Is that correct?
Yes.
Okay, so they're going to get a message to you between today and tomorrow as to where to turn in that gun. And Mr. Fisher, Who will
If,
give Mr. Fisher that information as to
maybe
where?
Maybe Miss Stafford can email me.
Okay. And you
Um,
put your
but
email in
this-
the chat to Miss Stafford?
I sure can. And then
Thank
if
you, Your Honor.
also, thank you, Judge. And also, Judge, can we also make sure that Miss Lee also returns any other possessions that she has in her possession that belong to my client?
I'm not gonna have her to bring a plastic bag to the sheriff's department. They're not gonna receive all that. He has a one-time escort to come to that property, not alone, but with the escort, to get his personal belongings. I don't know, that could be, 20 trash bags for all I know, but I'm not gonna have her to have to drag it somewhere else to take it unless that's something that Miss Lee wants to do, which I don't think that she does. They have no further contact. So they both need to be careful of that. But
Judge,
generally,
I'm not suggesting that. I'm suggesting that just if she has anything like a gun or keys or anything like that that she has in her possession that belong to my client, that they need to be available for my client to pick up when he comes with the marshal.
well, yeah, I'm assuming Miss Lee understands that whatever items belong to him, she's shaking her head. She'll have that ready when they come. They're going to have to contact her to set up a time anyway. Usually they do, I believe, as to when they're coming. I don't know if they just show up out the blue because she may not be home. Yes, Miss Lee?
Okay, so I'm off tomorrow. I do not have a car, so he can come tomorrow, or if we can set up a time for tomorrow, I'm off tomorrow. It can't be tomorrow.
I can't do it like that. And I'm not the one in control of
All
this.
right.
This is by the marshal's department. If you want to contact them as well, when you get off this call, or ask the victim witness advocate to assist you with arranging that is way over my pay grade. I don't do that with you, or don't do it on these court proceedings. That is something you all would need to work out. I doubt that it will be happening as soon as tomorrow. Probably not. Maybe a few days down the road. But you all will have to make those arrangements and carry that out. Your victim witness advocate may have some numbers or people that you can call to assist with that. So check with your advocate, and I know that ASG Stafford will have them to call you to arrange all of this, as well as assisting you and making sure that that unloaded gun is returned to the sheriff's department. I gave you a couple of days to do it. I'm not going to force you to have to do it by in the morning, because I doubt that anything will, the order will just be hot off the press. So as best you can do to do it as quickly as you can, and you'll just have to let the advocate, let Mr. Fisher know when all that is complete and done, and then the parents will either have to drive back here to get it, or it'll stay there until they're able to retrieve it. Okay?
Judge, will
Yes, sir.
someone contact me directly on when it will be set up for my client to go get his things?
I don't want to say things that are not in my knowledge either. Mr. Jordan, I don't know if ASG Stafford knows anymore. I know that you're somewhat new. I don't think they contact the attorney. I really don't want to speak out of turn on it. If Miss Lee gives them his number, as to what she knows to be a cell number, then they can contact him and arrange it. Or when Mr. Lindsay gets out, he can contact the marshal's department and say, I've got this order that gives me a one-time escort. He should still know her cell number as well. The marshals will call her and arrange that. So both sides can kind of in tandem, try to arrange it together. They will put the two together, given the case number and knowing what they need to do, and try to make those arrangements as quick as possible. But again, it has to be on, the marshal's schedule as to when they will be able to arrange that, make all that happen. So I don't want to say too much more than that, because I really just don't know how all the logistics work. It's not something that's done, immediately, in my opinion, because they do have a lot of other things to do and a lot of people to service. So I do know it has to be scheduled.
Okay, Judge. Yeah, we have a number
Yeah.
for the marshal's department at 612-4451. We can try to schedule it through that number.
Yes. Yeah. Sorry, I can't be any more helpful, but that's
okay.
all
you.
in their requirements. Okay.
Thank you.
All right. Thank you. Anything else, Mr. Jordan?
So is the weapon exchange gonna happen with the marshal?
Yes,
President?
well,
Okay,
well, we did say the sheriff's department, but I guess she can give it to the marshal, but the parents can only get the gun, not the defendant. So, you know, I guess you can, Miss Lee, are you still on?
Yes, I have. Okay, so his mom is not with his dad, so his dad stays by himself. So they won't be able to pick up the gun unless they bring his actual father.
Correct.
The person that's coming to help him is only his stepdad and his mother. Those two people do not own the gun. His father owns the gun. So
Hold on a second. Hold on a second. In the order, the gun is to be turned over to whom? What is his dad's name?
I don't know.
I'm not sure.
Mr. Lindsay, what's your father's name?
Bruce Lindsay.
Okay, so Bruce Lindsay is the owner of this gun. Is that correct?
That's correct.
All right, so that should be in the order that only Bruce Lindsay can obtain possession of this gun from either, and I'll put it in there, either the marshals or the sheriffs, whichever one get it first. And so Ms. Lee, check with the advocate and find out if the marshals can obtain that gun and have it there for Mr. Bruce Lindsay to pick it up from them. And if they tell you no, take it to the sheriffs, then you do whatever they instruct you to do. I'm gonna put either or in the order because the marshals might take it and give it to the dad, or they might tell you to take it to the sheriffs. I'm really not sure. Mr. Jordan, am I saying anything too incorrect?
well, I was just gonna say, I talked to the sheriff office and they said that they would prefer if they had to do it, it would have to be coordinated off-site. Because they
It'd
would
have to be
prefer-
coordinated off-site.
Right. So off-site from 185 Central Avenue, because they don't want anybody bringing any guns in the building.
Certainly. Just check with the advocate and let the advocate help coordinate this. I don't want to spend too much more time on it. So I've got a full calendar that I need to move. I'm going to leave all the logistics up to you all with the victim witness advocate, with the ASG and Attorney Fisher to coordinate it and talk to whomever on either side, sheriffs or marshals, and they will give you the instructions. And then ASG Stafford, if you've got the email for Attorney Fisher, you can email him and say, hey, we found out that the marshals are going to have the gun or the sheriffs, and just inform him as to where his client needs to, where his client's father needs to pick up the gun. Because I'm not sure right now where it's going to be frank with you. And Miss Lee, you can coordinate with the advocate as to where you should take this unloaded gun. Okay. All right. Thank you all.
Thank you, Judge. May I leave?
Thank you. Yes, you're free to go. Thank you.
All right, thank you.
Your Honor, can we go to position 10, the interpreter case? Ms. Connor Nova?
Yes.
Where's the interpreter?
Your Honor, my name is Olga Gorenstein. I'm a Russian interpreter here.
All right. Can you raise your right hand for me? Do you solemnly affirm that you will faithfully interpret from Russian to English and English to Russian the proceedings before this court in an accurate manner with to the best of your skill and knowledge with no embellishments?
Yes, I do.
All right. Thank you. All right. This is case number 23 CR 004060C. And it's State versus Miss Canova, charged with 1 count of battery family violence.
Это дело, номер дела, читает судья, заключается в том, что штат обвиняет мисс Кононову в домашнем насилии, в одно из обвинений домашнее насилие.
All right, pretrial told me this is a first arrest, so we can move on to the state.
Мне было сообщено, что это первый случай ареста в данном случае, поэтому я готова выслушать обвинения штата.
Yes, Your Honor. This incident occurred on June 28th, 2023 at 2415 Northwood Drive, Alpharetta.
Этот инцидент произошел 28 июня 2023 года по адресу 2415 Northwood в Альфаретто.
Officers responded to a physical domestic call. Officers spoke to the victim, Mr. Machine Deneke, who stated that he was sleeping in his bedroom when the defendant came upstairs and went through a cell phone.
And went to I'm sorry?
The defendant came upstairs and went through a cell phone.
Значит, полицейские отреагировали на телефонный звонок потерпевшего после 12 часов ночи. Потерпевший заявил, что он находился в спальной комнате, и обвиняемая, потерпевшего зовут Машин Денеки, если я правильно говорю, и обвиняемая поднялась наверх, зашла в комнату и взяла телефон мобильный.
He further advised the defendant became angry when she noticed that he had changed the password to his cell phone.
После чего было заявлено, что обвиняемая разозлилась, узнав о том, что паспорт в телефоне был изменен.
He stated that she then picked up his Apple MacBook and struck him in the elbow and in the chin area with the computer.
После чего сказал, что обвиняемая взяла Apple компьютер и ударила его в области локтя. This is an interpreter speaking. Please repeat elbow area. What was after elbow?
In his chin area with the computer.
Значит, что удар пришелся в области локтя, а также в области подбородка.
He further advised that the defendant was on top of him where he pushed her off to defend himself, and that during the process, the defendant bit his finger, causing a visible laceration.
После чего, значит, он сообщил о том, что обвиняемая оказалась сверху на нем, и когда он попытался столкнуть обвиняемую, произошел укус, он был укушен за палец, и произошло довольно заметное нарушение кожи, да, то есть прокус заметный глазом.
The victim also sustained visible scratches to his upper left arm.
Также у потерпевшего сверху на левой руке заметны следы царапин.
Due to the fact that these incidents occurred yesterday and there has not been an adequate amount of time for them to cool off, the state is recommending $3,000 surety bond, no alcohol, drugs, or weapons, no further contact with the victim, stay away from 2415 Northwood Drive, and anger awareness.
Значит, учитывая, что это произошло 28 числа и прошло совсем недостаточно времени, мы рекомендуем следующее наказание. $3000 поручительская гарантия, вот этот surety bond. Помимо этого, отсутствие, не запрещаем употреблять алкоголь, наркотики или владеть каким-либо оружием, стоять подальше от адреса 2415 Northwood Drive в Альфаретте и не иметь контакта с потерпевшим.
At an appropriate time, Your Honor, we ask that you sound for the victim.
I'm sorry, say it again.
At an appropriate time, we ask that the court sound for the victim.
И мы просим, чтобы суд был на стороне потерпевшего.
All right, Mr. Looks like he's here, Mohsen Denakani. Does he need an interpreter as well?
Скажите, пожалуйста, требуется ли переводчик потерпевшему, мистер Mohsen, если я правильно говорю имя?
All right. Does he wish to address the court today?
Hello?
Yes, do you wish to address the court today?
Скажите, что мне тоже переводчик нужен.
Just tell them I do need an interpreter.
Well, you're the interpreter, Madam Interpreter. Can you do it for both?
No problem. Let me just, I guess, introduce myself to him, make sure we have a good connection. Меня зовут Ольга, я также буду вашим переводчиком. Пожалуйста, говорите, я готова переводить.
Добрый день. Я полицию не вызвал. Я не был как потерпевший. У нас было недопонимание. Я на нее не написал заявление.
Okay.
Да.
Одну секундочку. So I just want to say, right.
I need to swear him in first. I need to swear him in first.
Окей, прежде чем я переведу то, что вы сказали, сейчас вас попросят поднять правую руку и принять клятву, что вы говорите правду.
All right. Does he affirm to tell the truth and nothing but the truth under the penalty of perjury?
Скажите, пожалуйста, клянетесь ли вы говорить правду, полную правду и ничего, кроме правды, иначе это будет наказание перед законом?
Клянусь.
I swear.
All right. What does he want to state?
Хорошо, пожалуйста, повторите, что вы хотели сказать судье.
Я полицию не вызвал. Я не написал заявление. Я не имею к ней никаких претензий. У нас было недопонимание.
Okay. Judge, I never called the police. I never, I didn't mean to write any complaints. It was just a misunderstanding. I really didn't want to call any police or cause any problems for her.
Следующий вопрос по поводу $3000. У нас мы приехали по программе U4U. Мы получаем до сих пор пособие государственное. Это очень большая сумма для нас, чтобы ее освободить. Я сам хочу ей помочь. Если мне это не будет разрешено, то через моего брата сделаем. Мы, скажите, я дальше.
So as to $3,000 bond, Judge, I would like for you to know that we came to this country on the program U4U, and we are still getting some help, from federal help. I would like to help to get her out of there myself. If I am not allowed, I will have to ask my brother to do that for me.
Да, мы получаем бенефиты государственные. И нам будет сложно заплатить $3000.
We do get federal benefits. It's going to be difficult for us to pay $3,000.
Да. И второе по поводу того, что я на нее написал заявление или требую, чтобы она была от меня подальше, или меня защищать, и чтобы она не была рядом со мной, это не получится, потому что я с того, как она ушла, не сплю до сих пор. Я не сплю, я с многими разговаривал, как уладить эту ситуацию. Я хочу, чтобы она вернулась домой. Я ее дома жду. И мы живем у моего брата. И она одна, у нее тут семьи нету, чтобы к кому-либо поехать.
Okay. As to the statement you mentioned about her staying away, I would like for you to know that since she left, I am not able to sleep at night. All I want for her to come back home. She doesn't have any other family but me and my brother. I need her home. I am not afraid of her. I want her back home.
Our system of justice doesn't move that fast. And her attorney can explain the bond process and the conditions.
Дело в том, что система правозащиты здесь в стране не так быстро двигается, как двигаются события в вашей жизни. Ее адвокат объяснит более подробно, как работают условия и правила вот этого залога.
Хорошо, я вас услышал.
Okay.
All right. And let me have PD Kim.
Yes, Your Honor. Ms. Kononova is 22 years old. She came to U.S. about a year ago from Ukraine.
Мисс Кононова 22 года, прибыла в Америку около года тому назад с Украины.
She does not have anybody else except him, literally. The place they live together, their names are both in the lease.
У нее действительно здесь никого нет, кроме вот ее друга, и контракт, по которому они проживают по месту проживания, на оба имени, на ее и на его.
She graduated from high school and 4 years of college, but their system is different, so it is equivalent to associate degree here in US.
Моя подзащитная закончила школу, также полностью закончила колледж, но так как система образования немного отличается от местной, то ее образование больше похоже на местное, которое называется Associate's Degree.
Even though she majored in the business and booking, right now she's currently employed at TJ Maxx and eyebrow salon.
Несмотря на то, что ее образование в области ведения бизнес-бумаг, а также бизнеса, на сегодняшний момент она работает в TJ Maxx, а также в салоне, который специализируется по бровям.
Since her boyfriend is not afraid and he does not mind for her to return home, we would like to request for a signature on bond and no further violent contact.
Так как ее друг, бойфренд, заявил, что он ее не боится и что он сам хочет ее возвращения по этому месту проживания, я попрошу суд смягчить наказание и согласиться на так называемый signature bond, то есть это залог под подпись, и чтобы вы приказали дальнейший контакт с насилием, то есть чтобы не было контакта с насилием, то есть не отрицание контакта, но отрицание контакта с насилием.
Your Honor, my client is the one who actually called for police to get help.
Судья, я прошу вас учесть, что моя клиентка – это тот человек, который позвонил в полицию.
It will be very hard for her to find new place because of her language barrier.
Ей будет очень трудно найти какое-то другое место проживания, учитывая языковой барьер.
We would like to request for a signature on bond and no further violent contact again.
Я еще раз хочу попросить вас о смягчении наказания в виде залога под подпись, а также исключения насильственного характера контакта.
Nothing further from defense.
Больше ничего.
Well, I have concerns about this incident, and I want to make sure that the victim is going to be safe and that there will be no further incidents.
Я немного обеспокоена этим инцидентом, и моя задача убедиться, что пострадавший в полной безопасности.
Можно я скажу?
Mr. Eggers? Okay.
Разрешите?
He is asking if he is allowed to say something, Judge.
Not much more. Something real short.
Можно, но, пожалуйста, недолго, у судьи мало времени.
Я хотел так же, как мисс Ким, попросить то же самое.
I just want to say that I am asking for exactly the same thing as Miss Kim did.
Okay, well, I have to make sure that there's been the ample or enough cooling down period.
Я должна убедиться, что прошло достаточное количество времени для безопасных отношений.
Это было недопонимание, и у нас не было никогда до этого ссор, и это было, наверное, последний раз и никогда не повторится.
It was just misunderstanding, Your Honor. We never had any arguments before, and I think it's never gonna happen again.
Я ее люблю и ей доверяю. Она не будет меня обижать. Я знаю.
I do love her, I do trust her, and I know she will not be violent or aggressive to me.
All right, I'm going to order the $3,000 signature bond through the jail. I'm going to order no further violent contact with the parties, with the victim.
Окей. Значит, я в свой приказ вношу такие пункты. $3000 залог под роспись, да, то есть под подписку. Второе, никаких дальнейших агрессивных контактов, то есть насильственных контактов. Контакт можно, но не насильственный.
And I'm gonna let the defendant know that if there's any more violent contact, she will be rearrested again.
И я должна сообщить обвиняемой о том, что если случится какое-либо насилие, насильственный контакт, мы имеем право снова вас арестовать.
I want her to stay away from the home, but I understand the situation and she has not been in the US long. So I'm going to allow her to go back as long as she won't be violent.
В принципе, я хотела запретить ей возвращаться по этому адресу, но я понимаю, что ситуация такая, что вы в стране недолго, и я разрешу вам вернуться при условии, что никакого насильственного контакта не будет.
Okay. I want to order an anger awareness course, but I won't do it because I don't know that we will be able to provide one in Russian. So I'm going to trust that there will be no more violence, no drugs, alcohol, weapons, or guns while on bond.
Я хотела бы обязать вас прослушать курс специальный, который обычно слушают люди в таких случаях, но понимаю, что вряд ли мы сможем предоставить это на русском языке, поэтому я вынуждена вам довериться и поверить, что не будет дальнейших насильственных контактов, употребления алкоголя, наркотиков или ношения оружия.
All right, that should conclude the case. Anything else, counsel?
На этом заканчиваем.
А мы можем забрать?
Can I pick her up?
Yes, in about 24 hours.
In 24 hours, Judge, you said?
Можно просто сегодня это сделать.
Смотрите, только что вы задали вопрос, судья отвечает через 24 часа. Такой был ее ответ.
Does he know where the jail is located?
Вы знаете, куда вам нужно приехать, где находится тюрьма?
Да. Мы недалеко, если можно, чтобы сегодня мы это сделали.
We are not far away. Do you think I can pick her up today? She has to go to work.
The jail doesn't operate that fast. They have to clear her for release, and she's not the only one. So that's why we tell people within 24 hours, because it is not a quick process.
Смотрите, ответ такой. Дело в том, что там есть определенные процессы, определенный протокол, который они должны соблюдать. Нужно оформить все документы, все. Поэтому ответ ее в течение 24 часов. Да? То есть она вам точно время не сказала, но в течение суток.
Это может быть и через час, да?
So it could be even in an hour if it's within 24 hours.
I think Ms. Kim is shaking her head. Yes, it's possible.
Она говорит, да, ваша судья машет головой, наверное, это возможно. Не судья, а ваш адвокат.
Спасибо.
I doubt it though, because we'll still be in court. They won't even have the order to release her until court is over.
Судья говорит, я на самом деле сомневаюсь, потому что через час мы еще будем находиться в этой комнате, в зале суда. У них еще даже не будут документы от нас, что ее можно освободить.
Хорошо, я уже буду у входа узнавать, что да и как. Я
Okay,
просто...
I will just be there by the entrance asking questions.
Okay, great. Thank you.
Хорошо, спасибо.
Я могу выходить?
Can I go?
Yes.
Да.
Ready.
Thank you, Judge.
All
for
right,
using-
thank you. I appreciate it. Thank you.
Absolutely. Thank you for using my services. Have a good night.
You
Have
too.
a good day,
Thank you.
everyone. Bye-bye.
You too. Bye-bye. Who do we have next, deputies?
Position 5, Davis.
Okay. This is 23 CR 004072Y, Lakeisha Davis, charge of 1 count of simple battery, family violence, pretrial.
With the rest, 2018, she don't have no violence in the history. That's it.
All right. State.
Yes, Your Honor. This incident took place on June 28, 2023. Officers responded to a dispute call at 1390 Piedmont Avenue. Upon arrival, officers spoke with the defendant, who advised that there was a verbal dispute that took place between her and the victim, whose name is Danielle Servance. I believe it's spelled Servance. According to the defendant, she had been in a romantic relationship with the victim. However, that relationship had been over for over a year, but they were still residing in the same home. She advised that she texted the victim to let the victim know that she was invited to a sleepover. The victim, the defendant advised that she was inside of her bedroom with another woman when the victim came inside the room and attempted to go to sleep in the bed. The defendant advised that she told the victim to go sleep in the living room, and that's when the argument started. Officers spoke with the victim, who said she came home from work and took a shower, and after that, she went and got in the bed. And that the defendant did not want her in the bed, and as a result, the defendant became very outraged and began to grab and push her out of the room. The victim reported a portion of the altercation and showed that to the officers. The officers noted that the defendant was the primary aggressor and that she could be seen striking the victim. And so as a result, the defendant was arrested. And the state is recommending, Your Honor, a $2,000 surety bond. They're asking for 1 day anger awareness, no further contact with the victim, and to stay away from the location and to have no alcohol, drugs, or weapons. And that location address again is 1390 Piedmont Avenue Northeast in Atlanta.
All right. Thank you. PD Wills.
Thank you, Your Honor. My client is 40 years old. As you heard, she has very limited criminal history and nothing violent on her record. My client was doing her former partner a favor by allowing her to live in her home as she had been put out of her mother's home. My client does deny all allegations as alleged. She is the owner, or her name is on the lease of that apartment. The alleged victim, again, she was just allowing her to stay there, even though they are no longer romantically involved. My client is the owner of She Knows Cleaning. She has been the owner of that company for 3 years. She will qualify to be represented by the Public Defender's Office. She has no children, and she does deny the allegations as alleged. My client has nowhere else to go, as this is her home and her residence. The alleged victim, again, was kicked out of her mother's home. So she does have relatives and somewhere else where she can go. My client has no objection to not having any contact with the alleged victim in this case. In light of my client's lack of any violent criminal history and her remote criminal history, I would ask for a signature on bond. If Your Honor is not so inclined, I would ask that her bond not be greater than $750, as this is a simple battery, which I do believe is a retaliatory report that was made against my client. And that is all, Your Honor. Thank you.
Well, I don't have a way to kick the victim out at this point. We normally don't have a habit of doing that because the victim at this point has the right to be safe. And do we have the victim on the call? Danielle Servants? Didn't sound for her.
Would you please, Your Honor?
Yes, Danielle Servants or Sevens. Don't think she's on the call.
And I have to advise my client about evicting Ms. Cervantes, and that was in order.
Go through that process, but I'm concerned about the facts as alleged and the incident between the two parties, and I just want them to obviously have no more incidents. So what I'm going to do is order a $2,000 signature bond through the jail. I'm going to order no further contact with the victim, Danielle Servants. I'm going to order a stay away from the 1390 Piedmont Avenue Southeast, but I will allow a one-time police escort to a law enforcement escort to return to that location to retrieve any personal items. If at that time it's determined that Ms. Severance doesn't reside there any longer or has no belongings there, then she can reside there, but only after the law enforcement have made a determination as to whether the victim still resides there. If she does, then she'll have to wait and reside somewhere else. No drugs, alcohol, weapons, or guns while on bond. And since she's working, I'm going to require her to take a one-day anger awareness course. And I guess that's it.
And Your Honor, can we, for the stay away, can that stay away be modified to stay away as long as the alleged victim remains at the premises?
Your Honor, I think your order addresses that by saying when she comes for the one-time escort, if the victim's not there, then she can reside there.
I would, well, she can go there on the one time, but if she leaves thereafter, I'm asking that my client be able to resume her residence as she pays rent there and her name's on the lease.
Well, I don't know how I can police that, meaning she's got to get 3 or 4 or 5 police escorts and try to go back at different times. I'm not for sure that law enforcement is going to be happy with me ordering them to do that. The one time, maybe she can wait a week before she does the one time and hope that the victim is out by then. But I'm not going to, predict or project too much down the road that she can go back unless she takes an officer to do it. But I'm not going to put that in the order specifically. But for her protection, she obviously should, if she finds out a month or 2 later that the victim has moved, then she can take an escort back with her, but I won't force that in the order.
Understood. Thank you.
Thank you.
Your Honor.
I'm sorry, Judge. Can you please repeat the bond?
$2,000 signature bond through the jail.
Thank you. Position 4, Ms. Bryant.
Okay. This is 23 CR 004068A. Katrina Bryant, charged with 1 count of simple battery family violence, pretrial.
Third arrest, 2019 FTA, 2019 trespass conviction.
All right, state.
Yes, Your Honor. The victim in this case was also arrested, but this incident took place on June 28th, 2023. Officers responded to a dispute call at the location of 1926 Grange Drive. There, the officers encountered the victim, Vertrell Pope, and the defendant, who were standing in the doorway upon arrival. The victim advised that he and the defendant were in a dispute regarding the custody of their child. And at that time, both parties appeared to shove one another. So that's when the officers spoke with them, and they both agreed that they would separate for a period of time to de-escalate the incident. The victim left the location with the child, and the defendant stayed at the location. The officer reports that he had to return to the location later the same day because both the victim and the defendant were physically fighting. The victim advised at that time that the defendant hit him several times upon his return to the location. And the defendant advised that the victim struck her and choked her, but not to a point of passing out. The officer then spoke with another person, Vertrell Pope, who advised that when the victim returned to the location, he began arguing with the defendant and a shouting match ensued. And after that, the victim slapped the defendant and they began fighting again. She advised that while they were fighting, there was a baby that was in the arms of the defendant. And the officer noted that both parties had visible marks on their body and they were both arrested. The state is recommending a $3,000 surety bond, a one-day anger awareness, no further contact with the victim, and to stay away from 1926 Grange Drive, and to have a third party for the exchange of the child, and no alcohol, drugs, or weapons.
All right. This is Ms. McLeod, which case? RPD Wills, which
No,
one?
Your Honor.
I
I'm on the other case,
Yes.
the cross
Okay.
defendant.
Gotcha.
Miss Bryan is 23 years old. She is a native of Atlanta. She is currently unemployed, and so she will qualify to be represented by the Public Defender's Office. Obviously, Mr. Pope is the father of her child, who was an infant. My client states that she has somewhere else where she can go, and she will be taking the child with her. I'm sorry, I don't recall what her history was, if it was put on the record. But even the alleged or the cross defendant, Mr. Pope, even his mother alleged that he was the one who instigated the physical altercation between her son and my client. I would ask for a signature on bond. Again, my client is willing to leave the residence. They are both young parents to an infant child. I think they are both probably stressed out. There might be some other factors contributing to their stress. And if Your Honor is not so inclined, I would ask for a $1,000 surety bond.
All right. I'm going to order the $3,000 signature bond. I'm going to order that signature bond be through the jail. I'm going to order stay away from 1926 Grange Drive. I'm going to order no further contact with the victim, Vertrell Pope. If there's to be any exchange of visitation with the children, that be precipitated by a third party. And no drugs, alcohol, weapons, or guns while on bond. And that's all I'll order at this time.
Thank you, Your Honor.
Okay. Can we have the companion case, deputies? I think it's 15. 16.
16.
Okay, and that was the total was a 3,000 SOB through the jail?
Yes, ma'am.
Okay, thank you. Position 16, okay, that's Mr. Pope.
Yes.
Oh, come on.
This is first adult arrest.
Thank you.
Your Honor, the facts are, they were alleged.
Hold on a
previous-
second, let me call it. 23 CR 00406-9A, Bertrell Pope, charged with 1 count of simple battery, family violence. Go ahead, state.
My apologies. Your Honor, the facts were, as they were alleged, earlier. And the state is recommending, $3,000 surety bond, 1-day anger awareness, no further contact with the victim, third-party exchange for the child, and no alcohol, drugs, or weapons.
All right, Ms. McLeod.
Yes, Your Honor. My client is 21 years old. He is not currently employed, although he should have started a job today, he tells me. He also tells me, Your Honor, that as the state and PD Will said, he shares a child who's not quite 3 weeks old with the cross defendant. He said that they were having an argument. He denies that he was the aggressor. In fact, he tells me that he left the location with the baby, he just went to the store, and that was what caused the initial argument because she didn't want him taking the baby. He does tell me that he's not afraid of her and he would prefer no further violent contact because they do have to parent this child. He had told me that if he had to go somewhere else, he could go and stay with his brother, but the court has already decided that she should stay somewhere else. So that is not an issue at all, Your Honor. But he does want to have no further violent contact with her because he does want to be there for his child. Your Honor, he has absolutely no history. I noticed pre-trial said his first adult arrest, but I asked him about his 1 juvenile arrest, which was for obstruction, and that was dismissed, Your Honor, so he has no record. I would ask the court to give him a signature bond so he can get out of jail and go back so that he can start working to help to support his child who's not quite 3 weeks old. Nothing further on.
All right. I will order the $3,000 signature bond through the jail. I'm going to order no further contact with the victim. And if there's visitation to be allowed with the child, that be precipitated by a third party. No drugs, alcohol, weapons, or guns while on bond. And I guess it's all out order at this time. Anything else?
Nothing further, Your Honor.
No,
Thank
Your Honor, thank you.
Thank you.
I'm at 30 later. Position number 9, Johnson.
you. 23 CR 004061F. Nyfield Johnson. You're charged with 1 count of following too closely. 2nd count driving while license suspended or revoked. 3rd count DUI under the influence of multiple substances. Pre-trial.
6 total. Last arrest was in January for obstruction. On probation for DUI. As of January, that's 23 CR 002874F. Got an open obstruction in public drunk. 23 CR 000423F. And defendant got some more DUI arrests in the history. That's it.
All right. State.
Your Honor, actually, Ms. Stafford is having some technical difficulties. She had to log off and she's trying to log back in right now. I think this is hers.
Okay, thank you.
You're welcome.
Let's see. I think I see her coming back. All right, thank you. ASG Stafford.
Yes, Your Honor, what position are we on? I apologize.
It's okay. We're on position 6. I'm sorry, position 9. Ms. Johnson, Nyfield Johnson, 9.
Okay, yes, Your Honor. This incident happened yesterday, on Georgia Highway Route 400. The defendant was driving on that highway when she rear-ended another vehicle. Upon officer's arrival, the officer detected an odor of alcoholic beverage on her breath. She later admitted to consuming multiple prescription medications prior to driving. When the officers ran her in GCIC, it returned that her license was suspended and had been suspended on April 4th, 2023. Due to the fact that she has multiple DUI arrests within the last 4 years, and there's currently an open warrant out of Gwinnett County for DUI and a possible open case out of Jackson County for DUI, state is recommending a $1,000 surety bond for following too closely, $1,000 for driving on suspended, $8,000 surety bond for the DUI, no driving, no alcohol, drugs, or weapons in ADET.
All right, PB Kim.
Yes, Your Honor. Miss Johnson is 36 years old. She was born in Minnesota, and then she came to Georgia about 10 years ago. She's very educated. She has a bachelor's degree from college in Colorado. She is registered nursing. She's about to she completed all the education. However, she couldn't get the license because of this issue that she has with alcohol. So actually she is registered and be ready to be admitted to Mercy rehabilitation place where she can go and stay there for about a year, and they will also help out with her housing resources after she completes her program. So we would like to request for signature on bond on the condition that she will be released to Mercy rehabilitation place. And she does have the person that she's been working with. His name is Stephen Rocks, and I tried to contact, but I could not contact before the court, and yet she does have a bed there. She is ready to go and get help. Thanks.
Okay, certainly want her to go get help, but I'm concerned about that. And since we have not made any contact with the Mercy Rehab, I'm assuming that's an inpatient. Do you know, PD Kim?
Yes,
If
it
it's
is
inpatient or
inpatient.
outpatient?
It
Inpatient.
is inpatient, Your Honor.
You know, and sometimes when we say only release to certain people, I guess that happens or doesn't happen. To know if she truly has a bed there or not.
Maybe we can have 24 hours from the release. If she is not released, if she does not get into Mercy Rehab, maybe she can be rearrested. We can give her 24 to 48 hours. Time limit.
Yeah, Mr. Jordan.
Cover Judge?
Have you heard of that before?
I'm sorry, I didn't hear what she said.
That if we tell her that she's released to Mercy Rehab, and within 24 hours, if she doesn't, she'll return to be rearrested. I don't think I'll see her again, or eventually, but I've not done that ever before.
But we can reissue the bench warrant, I guess, if she's not there by 48 hours.
It would have to be a bench warrant issued on the case. That's the only way they're gonna rearrest them.
Yeah.
Ms. Johnson, unless this is directly related to the bond hearing, please, I strongly recommend you to stay silent.
Does the state have any opinion?
Your Honor, I would object to the releasing her and then allowing her the 24 hours to either check herself in or be rearrested. As Mr. Jordan stated, unless there's a bench warrant out, I don't see where the defendant would willingly turn herself back in, as she currently has a warrant issued in another county. And then there is already a possible open case out of another county as well. At this point, it's like she's traveling Georgia in drinking and driving, or taking medications and driving. So I would object to releasing her for that 24 hours for her to turn herself back in.
Yeah, that's a little different. And I just don't know that I would trust it at this point, because she's with her history. History's not good. So what I'm going to do is I'm going to order a $7,000 surety bond with $1,000 on the following two close, $1,000 on the driving while license suspended or revoked, and $5,000 on the DUI. I'm going to order no drugs, no alcohol, no weapons or guns while on bond, no driving. She doesn't have a license anyway, so she doesn't need to drive. She should be taking Ubers and ride shares if she gets out on bond. I'm going to, I was going to order ADET, but I don't know if she's ever been evaluated or gotten treatment, or she knows she needs treatment.
She knows she needs treatment, Your Honor.
She seems educated. I don't know. It's interesting for her to be in nursing. Does she work?
Not at this point, Your Honor. She is striving to be getting better and get licensed as a registered nurse. She cannot get licensed at this point.
I can only imagine. I won't order the ADET at this time. We'll just see what happens if she makes bond, and hopefully on her own, she will go get some help and get started with rehabbing. But I won't order it. But she's got other issues with the other warrants, so hopefully she'll get some help somewhere along the way. That will conclude this case.
Thank you, Your Honor.
Who's next?
Judge, she had a question.
About the bond condition?
Yes, I don't have any family out here to assist me with the bond, and I just want to say I was in Alcoholics Anonymous during all of this. I know my history looks bad, but I promise you I was not just going from place to place. I was homeless. And I still am, and that affected my situation. Mercy Care, I just finished the alcohol evaluation program with my counselor, Stephen Rue, and he recommended the 90-day inpatient alcohol treatment. So I'm
But
just
I think the problem is you have two other open warrants, so.
I have courts for those. I have court for Gwinnett on the 12th, and I have court for Pendergrass on the 22nd of July. I just got out of court at Gwinnett, and he told me he was gonna give me a month to get a public defender. So I'm scheduled to go to court there. I've never missed a court date.
All right, well, I'm not inclined to give you a signature bond at this point with the history. And I hope that you can get the help that you need to get better and not pick up any more cases. So I'm gonna stick with the 7,000 surety bond for right now.
So if I'm here, how will I be able to make court? What, will they come get me?
Oh, I don't know. PD Kim can maybe inform them of where you are. If they order you to be brought there, I don't know. Or if they'll allow you to get on by Zoom, that will be up to your attorney to contact them to let them know where you are.
Okay.
But I'm not sure about that. It just depends on that jurisdiction.
I'm not allowed to miss the July 22nd court date.
I'm sorry?
I'm not allowed to miss the July 22nd court date at all.
Yep. Well, I know you're not allowed, but you know, you picked up a new case, so they'll deal with that accordingly, obviously.
Position 13, McCord.
This is 23 CR 004063D. Vera McCord, charged with 1 count of disorderly conduct, 2nd count of reckless conduct. Pre-trial.
Fifth arrest, 2020 theft by conversion. He was arrested twice in 2012 for domestic battery out of Illinois.
All right. State.
Yes, Your Honor, this incident occurred yesterday in the area of 2410 Benjamin Mays Drive Southwest. Officers responded to the area initially in reference to a report of shots fired. It was later upgraded to a dispute with a weapon call. Upon arrival, officers spoke to the victim, Ms. Alicia Vargas, who stated that there had been an altercation between her and the defendant, which is her neighbor. She stated that they have had a history of getting into verbal altercations. However, on this incident, the two got into each other's faces where threats to fight were made. Ms. Vargas stated that the defendant then pushed her and proceeded to grab a firearm out of her purse and discharged it approximately 3 to 4 times in the air. Due to the fact that this has just occurred yesterday, and there really hasn't been much time, and the defendant and the victim are neighbors, as well as the fact that this incident does involve a firearm, the state is currently asking that the $4,000 bond that is in place be increased to $7,500 for the disorderly conduct, $7,500 for the reckless conduct, for a total of $15,000 surety bond. No further contact with the victim is Alicia Vargas. Anger awareness, no alcohol, drugs, and weapons, and for the defendant not to be in any possession of any firearms, and if she has any firearms at home, to surrender them to the Fulton County Sheriff's Office.
All right. PD Kim.
Yes, Your Honor. My client, Ms. McCord, is 31 years old, single mother with 2 of her own kids and 2 other kids, nephew and niece. Basically, she's taking care of 4 kids. 2 of them, even though they're not her own, I mean, they don't have any other place to go, so she's the one who has to take care of them. She has been working at Atlanta Public School System at cafeteria. She got the new job yesterday. She was really excited to get more income. However, she's very afraid that she's going to get fired because of this arrest. And Your Honor, she graduated from high school and she is taking online courses for criminal justice at Atlanta Technical College. Right now, she does have a medical situation, high blood pressure, and all that other stuff that she has to take care of. We would like to request for signature on bond, and yet, if Your Honor is not inclined to give her a signature on bond because of the situation, we would like to request that $4,000 good bond will remain as set instead of getting increased. She really needs to go back home to take care of her children. She's been here in Georgia for 2 years. She does have connection here in Georgia, ties to the community, and we would like to request for $4,000 to be remained set. Thank you.
Okay, I am concerned about the use of a firearm in such a situation. Concerned that she has children who may have seen or witnessed the situation and wants to work around children. I have grave concerns about that, and possibly, anger awareness and handling your anger.
I believe, Your Honor, she was told that Alicia Vega's son was kidnapped. So there was a lot more intense reason for her to be more anxious, I guess. However, Ms. McCord, unless it is directly related to the bond condition, please do not speak anything. You have a right to remain silent. we don't want to hurt your case by speaking anything about the facts of the case.
Well, I know that I'm not here to weigh in on the facts that heavily, but it still sounds a little confusing to me. As to how the firearms were very concerned when people use that to resolve conflict. So what I'm going to do is I'm going to.
I'm sorry, Your Honor, sorry to interrupt. There never was firearm, as she said.
I think your attorney's gonna tell you to be quiet if you're gonna talk about the facts. Because you're getting ready to incriminate yourself.
No, I wasn't talking about no facts. It was just nothing, it was not firearm, it was fireworks. To be exact, that's why. It was.
I'm
never-
sorry, it was fireworks, you said?
Yes, we got fireworks. I have Roman candles for the kids, I have firecrackers and stuff. We never had when the police came, I'm sorry, it was never no firearm. I promise you that, Your Honor.
Okay. Well, what I'm gonna do is I'm going to leave your bond at the $4,000 surety bond. And that's 2,000 on each of the cases, is that correct?
1,000 for disorderly conduct and 3,000 for reckless conduct, Your Honor.
All right, I'll leave it at the $4,000 surety bond. Due to a little bit of history as well as the allegations. I'm gonna order no drugs, no alcohol, no weapons, no guns while on bond. And no further contact with Alicia Vargas. And who lives at the 2410 Benjamin E. Mays?
That is my client's address, Your Honor.
That's my address. That's me and my 4 kids that I now have custody of.
Okay, so I will not order a stay away, but certainly no further contact with Alicia Vargas. All right, so that'll conclude the case. $4,000 surety.
Thank you, Your Honor.
Mhm.
Position 6, Felder.
First arrest.
Thanks. 23 CR 004070F, Willie Felder, charged of 1 count of criminal trespass, family violence, and a 2nd count of simple battery, family violence. First arrest, state.
Yes, Your Honor. This offense took place on June the 26th, 2023. The defendant, the officer states that the defendant grabbed his girlfriend, Nataria Russell, by the hair and pulled her out of her home and onto the front yard, and then struck her with a closed fist. The defendant and the victim, Nataria Russell, have a child together. And also, the officer noted that he saw where the defendant kicked in the door, the front door, and caused severe damage to the door and to the frame. We've spoken with the victim, and she indicated that they have not had history in the past, and she's not afraid of the defendant, and that he did not hit her, and she doesn't know who kicked the door open. And she stated that her foot was bleeding because she stepped on a nail. She indicates that she wants contact and she wants the defendant to return to the residence. However, Your Honor, the state is recommending a $3,000 surety bond, $2,500 for the simple battery and $500 for the criminal trespass, a 1-day anger awareness, no further contact with the victim at this time, and to stay away from the location of 941 Reed Avenue, and to have no alcohol, drugs, or weapons, and to have a third party to exchange their child.
Okay.
If we could please sound for the victim, she is on the call. She has reached out to me.
Thank you.
Messenger.
All right. The victim, Nataria Russell.
Yes, I'm here.
Do you wish to address the court today?
Yes, ma'am.
Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, what would you like to tell me?
I want to start off by saying that the whole police report is false. The police officer who actually made the report, he's been harassing my family. None of the events that he said took place actually happened. We've never gotten a violent argument. We don't have any criminal history, me or him. His record is clean and he's a good father to my child. I feel like he do not need to be away from our daughter. She's 3 years old and she need a father. He's a good support system to me, my mom, and also his family. And him sitting there in jail for something he didn't do, I don't feel like that's right. And like I stated before, I didn't press charges or I didn't make a police report. The whole police report is false. And the police officer who actually made the report, he's been harassing my family because he cannot get my brother. He's been questioning my family. The day the event took place, he questioned all my family members about when the last time we saw my brother and heard from my brother. And he actually threatened my child's father, saying that he was going down just because my brother wasn't here.
Okay. So are you in fear of Mr. Felder?
No, I'm not in fear of him. I actually feel protected when he's around.
Okay. Thank you. Any cross-examination by the state or by PD Wills?
Okay, wait, you gotta take a shot.
I'd just like to ask, did the officer come to your, was it 941 Reed Avenue and make a report? I just want to clarify that. Is she still there, Ms. Russell?
I think her child may have.
Yes, I'm sorry. I thought I muted it. Yes, he said that he witnessed the whole situation, but I actually have witnesses who was here who actually saw the whole thing. The officer was never here. And I made a call with him too, and he notified me that he made the report.
And was he at your home on June 26th?
June 26th, he approached the scene like 10 minutes later.
Okay, thank you.
PD Wills?
Your Honor, my client is 19 years old. My client also shared with me that this Officer Melton, has been harassing my client. Also, as the alleged victim stated, law enforcement was there for another issue, not pertaining to my client. And they told my client that because they could not locate the individual that they were searching for, that they were going to arrest him. I've already advised my client to file formal complaints against the police department, as well as that officer who has been harassing him on several occasions. He is just 19 years old, but he has a 3-year-old child whom he shares with this alleged victim, showing that they are in a committed, dedicated relationship, and he has stepped up to handle his responsibilities. He does have a diploma from Life Christian Academy. He does deny the allegations as alleged. He has been in jail since the 26th, Miss, you don't need to, yeah, he's been in jail since the 26th. He was first locked up in East Point before being transported to Fulton County. And so I would ask, especially in light of this being my client's first arrest, that he be granted a signature bond. If Your Honor is not so inclined, I would ask for his bond to not be greater than $1,000. He has indicated that if there is no contact provision made, that he does have somewhere else where he can stay, but he would prefer to have no further violent contact with the mother of his child.
Okay. I'm going to order a $3,000 signature bond through pretrial per judge. I'm going to order no drugs, alcohol, weapons, or guns while on bond. I'm going to order the 1-day anger awareness course through pretrial. I'm going to order no further. I'm a little torn about the contact because there's some allegations here and I'm not for sure what's going on. So Since he does have somewhere else to go stay, let's do the stay away for now to make sure things have cooled down. The stay away from the 941 Reed Avenue. And even though there is the stay away, I'm going to order no further violent contact between the parties. So that if they need to do an exchange with the child, they can do that since there's no further violent contact, okay?
Thank you, Judge.
All right. Does he need a one-time escort to get any items?
You don't need to say anything else. There's no further violent contact and he has a signature bond. So you don't need to say anything else.
Does he need to get any items from that property?
I would ask for a one-time law enforcement escort for him to gather the legacy he has there. He was living there, yes.
Okay. All right, one-time police escort in order to get any personal items that he may need while he's on bond. Yes, Ms. Champion?
Yes, Judge, can you give me the breakdown on the bond, please?
Oh, I'm sorry about that. 2,500 on the simple battery and 500 on the criminal trespass.
Thank you.
Thank you. All right, there's nothing else. Does that resolve this case?
Yes, Your Honor.
All right, thank you.
Position 2, Brannigan.
This is 23 CR 004066D. Calvin Brannigan, charge of 1 count of simple battery, 2nd count willful obstruction of a law enforcement officer, 3rd count theft of services, and a 4th count driving expired and no license plate or decal pretrial.
He got 3 cycles. 2 previous cycles look like they come out of the Air Force. Wrongful use of a controlled substance of 2021. 2021 failure to obey an order for sexual harassment, simple assault. That's it.
Okay. State.
Yes, Your Honor. This incident took place on June 28th, 2023. Officer was called by a restaurant, I believe it's called Volaire Restaurant, about a theft of services. And it was reported by the 911 center that the suspect went out of the restaurant and the 911 center provided a description of his appearance and his car. Officer, when he arrived at the location, he blocked off the car, which was said to be at the post office, and all of the restaurant employees confirmed that the person that had left the restaurant was the person that was in the car. So the officer went up and addressed the defendant, the suspect, and the suspect explained to the officer that he found the food at the restaurant to be improper food, and he thought that the employees had tampered with his food because they were laughing in the back while he was eating, so he left. In addition to that, officer asked about his license tag because the license tag was a Delaware license tag, but the defendant had a Georgia license and had a Georgia license for over a year. When the officer explained that he was trying to investigate about a theft for services, the defendant became very aggressive, and the officer held out his hands to try to encourage the defendant to calm down. And the defendant became more aggressive and told the officer to be careful. That's when the officer told the defendant that he needed to be more careful. And he explained to the defendant that he was going to detain him while he investigated. The defendant became more aggressive in his behavior and in his mannerisms. And when the officer attempted to try to open the defendant's car door to secure him in handcuffs, the defendant pulled the door closed. The officer tried to open the door again, and that's when the defendant pulled the door closed a second time. So the officer reached through the driver's window to handcuff the defendant, and the defendant swung a closed fist towards the officer's face. And then he dug his fingernails into the officer's arm. And when the defendant reached towards the console in the car, that's when the officer drew his pistol on the defendant and told him to show his hands. And for this reason, by that time, there were multiple officers who showed up and they were able to take the defendant in. And for that reason, the state is recommending a $3,500 surety bond, $2,000 for the simple battery, $1,000 for the obstruction, $250 for the theft of services, and $250 for the no license plate. To take the anti-theft class and to not drive until the tags have been transferred properly to Georgia.
Give me the breakdown again.
$2,000 for the simple battery, $1,000 for the obstruction, $250 for the theft of services, and $250 for the no license plate.
All right. PD Wills.
Thank you, Your Honor. My client is 23 years old. I understand, Mr. Brannigan, you have something to say, but we've already spoken. You'll have your day in court at a later date, okay? This is just your bond hearing, all right? He is a military veteran. He served 5 years in the Air Force. He does suffer from PTSD. As far as the theft of service charge, I believe that could be a civil suit that can be handled at a different date or in a different court. In regards to the rest of the charges, my client does deny the allegations as alleged. He states that law enforcement attempted to grab him. He pulled his hand away. In no way did he attempt to strike or injure or scratch or hurt law enforcement in any way. He does suffer from some housing insecurity at this time, but he does have a plan, and he is currently housed. He's staying at a motel and does not need assistance with housing. As a result of this incident, his car was towed. So he has lost all of his belongings, and he has, upon his release, has to deal with paying whatever fees are associated with him having his property released back to him. He has very limited criminal history. I would ask that he be granted a signature bond. And if Your Honor is not so inclined, I would ask that his bond not be greater than $1,000 for all 4 of the charges at this time. Thank you.
All right. And I'm going to order a $3,500 signature bond. And I'm going to order that signature bond be through the jail. So that'll be $2,000 on the simple battery, $1,000 on the willful obstruction, $250 on the theft of services, and $250 on driving on an expired tag. He is to not drive until he can get a tag or the right registration on that vehicle. So he shouldn't drive until that happens. I'm going to order no drugs, alcohol, weapons, or guns while on bond. And stay away from the incident location, the restaurant. Stay away from there. And I guess that's all I'll order at this time.
Thank you, Your Honor. You received a signature bond, Mr. Brannigan. Thank you.
Hey, how much is that?
$3,500.
Position 14, Mr. Miranda.
You can walk in.
This is 23 CR 00405998B. Eduardo Miranda, charged with 1 count of simple battery family violence. And understand for pretrial, this is a first arrest. So state.
Yes, Your Honor, this incident occurred on June 27, 2023 at 13660 Bethany Road in Milton. Officers were dispatched to that location in reference to a physical domestic dispute. Upon arrival, the officers met with the defendant and the victim, Ms. Paula Del Arvia, who stated that during altercation within that residence, the defendant intentionally bumped into her while she was holding her 1-year-old son in her arms. Due to the fact that a child was involved in this incident at the time it occurred, the state is asking for a $3,000 bond. However, they are in agreement to a signature bond through pretrial. No further contact with the victim. Stay away from the incident location, 13660 Bethany Road in Milton. No alcohol, drugs, and weapons, and anger awareness.
All right, PB Kim.
I sincerely apologize. My client is Miranda, 20 years old, Your Honor. This was kind of like an incident that was a lot of misunderstanding between him and his brother and his brother's wife. He is actually in the middle of going back to rehab program. He has some issues with a drug, and he would like to go to no longer drug bound. It is located at Cumming, Georgia, and he is scheduled to go there next week. He already completed blood work yesterday. Before he got arrested. Your Honor, he does not have any employment at this point. After completing senior year at the high school, he could not graduate from high school. He worked for construction, and yet he realizes that he needs more help from the rehab program. So we would like to request for a signature on bond on the condition that so he can go actually get help.
I think the state has offered a $3,000 signature bond through pretrial.
Yes, Your Honor, that was our
Only thing is though, could it be done through the phone? So that way my client's gonna be in-house inpatient program, so he may not be able to come out of the program. So he has to do it by phone.
Well, he can go through the jail.
Okay. Let's do a $3,000 signature bond through the jail.
Thank you.
And we will order stay away from 13660 Bethany Road in Milton. No further contact with the victim, Paula Dalverio. I don't know what the last name is.
Under my name.
Mr. Miranda, you just got a signature on bond. Please do not say anything.
Oh, it's just a question about my house, because.
You call me, I'll be happy to explain everything.
Yes, ma'am.
Thank you.
And no drugs, alcohol, weapons, or guns while on bond.
Understand.
All right, that will conclude this case.
Position 7, Hill.
This is 23 CR 004071F Mario Hill. 1 count of battery, 2nd count of criminal trespass and damage to property. Pretrial.
18 total 2021 battery, cruelty to children. On probation for PR. Got a 2010 robbery by sudden snatch, guilty. 2012 burglary, first offender. 2014 simple battery, simple assault conviction. 2014 theft by receiving obstruction conviction. 2019 probation. 2020 trespass conviction. That's it.
All right, state.
Yes, Your Honor. This incident took place on May 7th, 2022. And in the warrant, it said that the defendant, the victim took the defendant to work. And on the way to take him to his job, he said he wanted the 1581 Kimberly Way Southwest. And the victim told the accused that she wanted to end their relationship. That's when the defendant became angry and asked the victim to give him a ride to the store. The victim refused. The victim also noted that when she did that, the defendant became angry. He forcibly grabbed her necklace, her bra strap and her tank top and tore it away from her body. And he left a long visible scratch along her chest area and caused her pain. The victim says that they have DV history or violence in their history, and that she's afraid of him. She says that he's stalked her before and he has threatened her, and that she's confirmed everything that happened in the report, and that she also stated that she has a TPO against him. We've seen the application, but we couldn't find the actual TPO in the system. And she's asking that she doesn't want any further contact with him. And the victim's name is Nikita Hambrick, and at the appropriate time, I would ask that you would sound for her. And the location, the defendant's mother's home is 1381 Kimberly Way, so she's not going to go there. And the state is going to ask in this matter, we're going to recommend for a 2,000, well, actually a 2,000 cash bond and no further contact, no alcohol, drugs, or weapons, and a 1-day anger awareness.
What's the breakdown on the 2,000 recommendation?
1,000 for the battery, 1,000 for the criminal trespass.
And were you asking for a stay away or not? Who lives?
We're not going to ask for the stay away because she's no longer, she's at a new address and she does not want that address made public or in court, but she does not want him around. So we're going to ask for no further contact.
Okay. All right. PD Wills.
Thank you, Your Honor. My client is 31 years old. I would ask that, or I believe that a cash bond is excessive and would be punitive to my client at this juncture. This incident occurred May of 2022. There have been no further incidents or contact. My client states that he is no longer involved or has spoken with or had any communication or contact with the alleged victim in this case since last May. He does not reside there. He is a native of Georgia. He's a manager at Checkers. He will not qualify to be represented by the Public Defender's Office due to his income. He has a 13-year-old child as well as an infant, not mothered by the alleged victim in this case. He does deny the allegations as alleged. I would request a signature on bond. My client also has some felony charges that he went to court for earlier today. So I take it at the time I spoke to him, he had not received a bond in those cases, but I believe he probably or likely does have a bond in those cases now that I presume would be a lot higher. So I would ask for a signature on bond. If Your Honor is not so inclined, I would ask for $1,000 surety bond for both cases or both charges, excuse me.
And Your Honor, I'd just like to add that the state is going to object to a signature bond, and that is because because of his violent history, Your Honor. We're going to ask for the $2,000 cash bond, and if not the cash bond, a surety bond.
Okay. I'm going to order a $2,000 signature bond through the jail. It's $1,000 on each of the charges. I'm going to order no drugs, alcohol, weapons, or guns while on bond. No further contact with Nikita Hambrick. That's 1,000 on each of the charges. I guess that is all out order at this time. Anything else, counsel, that I've missed?
Nothing from the defense. Thank you, Your Honor.
No, Your Honor.
All right.
Position 11, Ledbetter. Have a seat.
This is 23 CR 004057C. Raymond Ledbetter, charged with 1 count of battery family violence. Pretrial.
7 total, 2020 FTA. On probation and car bag assault. 2019 probation, 2017 simple assault, NOLO.
All right, state.
Yes, Your Honor, this incident occurred on May 29th, 2023. Officers were flagged down near Woods Drive Northwest and Bakers Road Northwest by the victim, Ms. Nateri Davis. She stated that she was in a domestic dispute with her child's father, the defendant. She informed officers that she wanted to relocate to the precinct to talk as she felt safer at that location. Once at the precinct, she advised that the defendant, and her child had a incident at the MARTA station where they were kicked off due to not having enough money for the train. And as they were walking to the CVS located at 2429 Martin Luther King Drive, she became angry when she realized that they didn't have enough money to buy the baby any diapers. And she stated that at that time, the defendant began to kick her repeatedly in the legs, causing both of her legs to swell and bruise. She stated that they then walked home, and on the walk home, the defendant continued to threaten her, stating, "I'm gonna put you in the ground." She stated that the defendant then pushed her and their son down, causing them to fall into a ditch. Due to the fact that the defendant currently is on probation for a violent offense and has a violent history, the state is currently asking for a $7,500 surety bond. No further contact with the victim, Nefertiti Davis. Stay away from 2749 Dale Creek Drive, Northwest in Atlanta, which is the victim's address. No alcohol, drugs, or weapons, and anger awareness.
All right, PD Kim.
Your Honor, this is Jay Kim. I apologize, but I do have a phone call from Miss Ledbetter's girlfriend, Nefertiti Davis, right now at the other line. She really wants to say that she's not afraid of him. She wants him to come back home. And I have been trying to manage the phone calls and the hearing at the same time. I apologize for that. And so we would like to request for no further violent contact. This happened on May 29, Your Honor. It was a while ago, almost about a month ago. They are happy together. They have a 1-year-old baby who's gonna have a first birthday on July 7. And my Miss Davis wanna be on the Zoom. However, she does not have a Apple ID password to download the Zoom, and she's actually calling me right now. So I was wondering if the voice might be good enough at this point. Mr. Ledbetter is 31 years old, and he's been operating his own truck business. He's graduated from high school. And he's been here in Georgia for more than 15 years, and he's the sole provider for Miss Davis and the baby. So we would like to request for a signature on bond and no further violent contact. If Your Honor is not inclined to give him a signature on bond, at least no further violent contact, maximum $1,000 good bond. Thank you.
She's on there. She's on there. She's on there. Judy.
Who's speaking?
Oh yeah, she's on there. Judy. Yeah. Nefertiti Davis. Yes. It's Judy Gorman. You see it?
Oh, Judith Garman. Is Nefertiti Davis on the Zoom call?
Yes.
If she doesn't speak up soon, I'm going to go past her. So she's got to turn her camera on, be on speaker.
Okay, I'm sorry. I'm so sorry. So I don't know how this works, but let me start the video. And can you hear me?
Yes. And your name is?
My name is Nefertari Davis. This is I'm calling you from my neighbor's Zoom.
Okay. And do you wish to address the court briefly?
Yes.
Raise your right hand for me.
Yes.
Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am. Yes,
All
Your Honor.
right. All right. Are you in, you can put your hand down. Are you in fear of Mr. Ledbetter?
I'm sorry, I'm not in fear of him. No,
Okay. Do you want to have contact with him?
I do.
Okay. All right. Any cross-examination by the state?
I'm sorry?
No, Your Honor.
Okay. Any cross-examination, PD Kim?
No, Your Honor.
Okay. Those are the two questions that I need to know, contact and whether you're in fear.
I'm not
And
in
you have
fear.
stated that you're not. All right. That's all that I need to know at this time.
Your Honor, can I make a brief statement?
Okay.
Okay, so my intentions for filing the police report was because he stated verbatim that I'm going to lose my son. So that was the reason for me filing the police report to, you know,
May I please?
Yes.
make sure I was protecting him and myself in case I had to go to a shelter or something of that, you know, something of that nature. So that was.
May I please ask Miss Davis to objection, please. I think we already have the enough information, so we don't need any more information.
Okay.
I was gonna authorize a payment, how much?
This is not a trial. This is just bond hearing. And as long as you want to have a note for the violent contact, I think that should be sufficient.
Okay, and I'll be able to get him out today?
I do not know the answer.
You can't answer that?
Ms. Garman, you can mute.
All right, that's Miss that's not Miss Garman, that's Miss Davis.
Yes, I'll mute.
Okay. All right, anything else, PD Kim?
Nothing further, Your Honor.
All right, due to the history of the defendant, I'm going to order a $5,500 surety bond. I'm going to order no drugs, alcohol, weapons, or guns while on bond. I'm going to order and let me ask this, the Dale Creek address is the address for Miss Davis?
Yes,
Both
Your
of
Honor.
them.
Both of them reside there together?
Yes, Your Honor.
Yes.
Okay. I'm going to, based on Ms. Davis's testimony, I'm going to, because I feel like there's hopefully been the ample cooling down period and there will be no more incidents. I'll order no further violent contact between them. And if they both reside there, I won't order the stay away. But I am going to order a one-day anger awareness course for Mr. Ledbetter. Since he is working, he should be able to afford to take that course. All right, anything else?
Nothing further from defense.
All right, thank you.
Judge, did you say 5,500 surety bond, good bond?
I did, yes.
Thank you.
Mhm.
You're done. Position 1, Alvis.
All right, this is 23 CR 004065B.
Mr. Brewer.
Kelvin Alvis, charged with 1 count of reckless conduct, the 2nd count of pointing or aiming a gun or pistol at another, free trial.
Fifth arrest, 07 was the last for DUI.
Okay, state.
Yes, Your Honor, on June 28th, 2023, officers were dispatched to 610 Spring Street Northwest in reference to a person's arm call. Upon arrival, officers met with the property security officer, and that's the defendant. The defendant stated that he was working at the location while conducting a normal foot patrol. He noticed an unknown male wearing a gray t-shirt and blue jeans panhandling on the property. The defendant stated that he approached the male and demanded that the male come off the property. He also stated that he spoke to the male and the male became aggressive and started making threats towards him. He stated that the male started walking towards him aggressively, and that's when he pulled out his ASP baton to defend himself. He also stated that when he pulled it out, the male ran into a grassy area and yelled out, "I got something for you." That's when the defendant stated that after the male made that statement, he began walking towards the defendant. The defendant stated that he couldn't tell whether he was armed or not. So he pulled out his firearm and shot one warning shot. He said he wasn't aiming at the male, he was just shooting close enough. And when the officers arrived, that male was not on the scene. However, the officers were able to speak with a witness who stated that he saw the entire altercation between the security officer and the other male. The witness stated that the security officer was chasing the male around. And he also stated that the security officer did aim and point the firearm at the male, but the male was not hit by any bullet when the security officer fired. So the state is recommending in this case a $10,000 surety bond. We're asking for no weapons, alcohol, or drugs. We're also asking that the defendant surrender all firearms to the Fulton County Sheriff's Office and that he may not be able to carry a firearm at work.
Who is the victim?
It's an unknown male. The police were never able to locate the unknown male.
Okay.
However, there is a video, a partial video of the incident.
All right. Ms. McLeod?
Yes, Your Honor. My client is 59 years old. As Petral has stated, any criminal history that he may have is unrelated to this incident and also remote. I believe Petral said he had a DUI in 2007. My client works, he works and has been working for some time as a security officer at this particular location. He tells me that the alleged victim was on the property harassing customers, and he asked him to leave several times and he refused to leave. He came back there, was panhandling, and my client asked him to leave again. This was when he threatened my client. When he told my client that he had something for him and was coming towards him, my client had to protect himself. So he essentially fired a warning shot. Obviously, if he had pointed the gun at him, it would have hit him because there was a bullet in the gun. So he did not point it at him. It was just a warning shot that he fired, Your Honor. Given what has been stated here and what my client had to say for himself, his history, and the fact that he was in the course of his job as a security officer when this incident happened, I would ask the court to consider giving my client his signature bond so he can get out of jail and get back to work. I understand that they say there's a partial, and we'll note partial video. Hopefully there will be some footage there which shows the total incident that happened, Your Honor. But just given the fact that any kind of criminal history my client has is remote, the fact that the alleged victim is nowhere to be found, I would definitely ask the court to consider giving my client a signature bond so he can get out of jail and get back to his job. Nothing further, Your Honor.
All right. I'm going to order $5,000 signature bond through the jail. I'm going to order no drugs, alcohol, or weapons while on bond, except for the weapon that he must carry for his job. I'm not gonna order the surrender. I'm going to, and that's it. That's all I'm going to order.
Thank
'Cause
you.
The 610 Spring Street is where he works,
He
correct?
works there, Your Honor, that location, and has been working there for some time.
All right, so just the $5,000 signature bond through the jail.
Thank you, Your Honor.
Mhm.
Your Honor,
Honor,
can I have the
that
breakdown
concludes
of the bond, please?
So that'll be 1,000 on the reckless conduct and 4,000 on the gun charge.
Okay, thank you.
Thank you.
Your Honor, that concludes my business before the court today. May I be excused?
Yes, you may.
Thank you,
Thank
Your Honor.
Position 3, Brewer.
This is 23 CR 004067J. Larry Brewer charged with 1 count of certain acts on a bus or rail station prohibited and a 2nd count of criminal trespass pretrial.
54 total,
How many?
54.
54.
He on probation for burglary. We got a lot of probations and his trespasses in this issue. That's it.
All right. Date.
Yes, Your Honor. This incident took place on June 28th, 2023. The officer was working in plain clothes doing undercover surveillances, and an unidentified male that they later identified as the defendant was drinking a Bud Ice alcohol beverage at the bus stop route number 55 on 30 Alabama Street Southwest in Atlanta. The defendant was approached and advised of his violation. He was asked for his identification, which he provided, and they did a MARTA check, a MARTA suspension check, and it was revealed that he had been suspended on December the 1st, 2022, and that he was supposed to resume in July of 2023. And he later received a permanent ban from MARTA, violated that when he was on MARTA, on the MARTA site on June 28th, 2023. The state, right now, there's been a bond set for 600 surety for the first and 600 surety for the second charge. And we're gonna ask that the bond remain as set, and for the defendant to stay away from MARTA and to adhere to the restrictions of MARTA, and that's a permanent ban.
All right. P.D. Wills.
Your Honor, my client cannot afford the current bond as set, the $1,200 total. I'm gonna ask for a signature bond. If Your Honor is not so inclined, I would ask for a $600 total bond for both charges. And even reading the warrant, it's a bit confusing for me. It says that he was issued a MARTA suspension December 1st, effective June 3rd, and then to resume July 2nd. And then also received a permanent ban December 27th. That's confusing for even me to understand. My client states that he did not know that he was banned. He understands that he now understands he is banned. He does have some concerns as he does not drive, but I have informed him that as there is a permanent ban, that he cannot take MARTA, that he needs to either employ an Uber or find some other means to get to wherever he needs to go. He works odd jobs, but makes very, very little money. And he does qualify for our services. He lives at home with his mother. Again, he is 61 years old. He lives in Ellenwood, Georgia. And so that is my argument for the court.
Okay. I'm going to order a $800 surety bond, 400 on each of the charges. And with that $800 surety bond, to follow all MARTA suspensions and bans. Looks like he's not supposed to be on MARTA. And no drugs, alcohol, weapons, or guns while on bond. And that's all I have to order at this time.
Thank you, Your Honor. Mr. Brewer, you don't need to say anything else.
Thank you,
He
Your Honor.
understands that you cannot afford it. I've already explained that to the judge, okay? So it's an $800 surety bond.
Can I ask you something? What is a surety bond?
I'm gonna tell you, I'm gonna explain it to you.
I see it, I see it.
Yeah. I got a few announcements, Judge.
Okay.
All right, Mr. Brewer, have a seat. For position number 8, Eric Holmes, they refused.
I'm waiving his presence today. Mr. Howard has spoken with him, so we
Okay.
can proceed.
And also position number 17, waive their appearance.
Okay.
And I did submit both waivers for both Mr. Holmes and Ms. Ward.
All right.
And we're completed here in courtroom 2, Judge.
All right, thank you.
Thank you.
All right, we ready with position 8? 23 CR 004023B, Eric Holmes, charged with 1 count of criminal trespass, a 2nd count of willful obstruction. A law enforcement officer, pretrial said it was his first.
Yeah, he don't have an
Yeah.
address, so that would be SOB jail if you gave it to him.
Okay, thank you. All right, State.
Yes, Your Honor. On June 24th, 2023, officers responded to 1105 Northside Drive Northwest at the McDonald's in reference to a criminal trespass call. Upon arrivals, officers encountered another officer who stated that he needed assistance to remove the defendant from the property. As officers attempted to remove the defendant from the property, he actively resisted from leaving and refused to leave. And because of that, the state is recommending a $2,000 signature bond through the pretrial services, $1,000 for each count, and to stay away from the McDonald's on 1105 Northside Drive Northwest, and to have no alcohol, drugs, or weapons.
All right. PD Wills.
Are we able to either stop the recording or can we stop the recording briefly?
All right.